Would Ms. Lim agree that the sentence imposed on Dr. Wu was in line broadly with the cases I've shown? I'll invite her to answer the question.
Sir, I thank the Minister for the schedule of facts that he has listed out for the House. The reason why I filed the question largely was because of the issue in the public discussion about equitability of the legal. And while I am aware of some of those cases where fines were imposed, there are also other cases where imprisonment was imposed. And lawyers who are familiar with this area of practice, they tell me that Dr. Wu got off. And I'd like perhaps to ask the Minister for his view on some of these possible aggravating factors in Dr. Wu's case. First point is that it appears from the police investigation that it was Dr. Wu's idea for Kwan to provide the information to the police. And he did it with deliberation. He received the forms from the traffic police, but decided not to get his hands dirty and ask his employee instead to provide the information. Second point is it occurred over a period of time. It was multiple offences, once in 2005, second time in 2006. So it's not a case of a spur of the moment kind of conduct, but conduct over a certain period of time. Thirdly, the motive of Dr. Wu instigating Mr. Kwan to provide the information is that he wanted to shield himself from collecting points, which possibly could result in his disqualification from driving subsequently. This is one of the factors which the court has said the motive that the person, in the person's mind when the false information was provided is very important. So these are some of the aggravating factors in Dr. Wu's case, and I wonder if the Minister would agree with that.
I will be happy to answer them, but I noticed Ms. Lim avoided answering whether she thinks, and she's a qualified lawyer, whether the cases that I've listed suggest that Dr. Wu's case and the treatment fell broadly in line with the punishments meted out in those 6 cases between 2004 and 2007. Could I have an answer?
Speaker, as I mentioned earlier, I'm aware of some of these cases where fines were imposed, but as I said, there are some aggravating factors in Dr. Wu's case which I believe should have been taken into account, and that has led to this opinion on the part of criminal lawyers as well as members of the public.
Well, let's look at the points that Ms. Lim makes. Motive. In each of those cases I pointed out, there was the same motive, to not identify oneself. And in each of those cases, Ms. Lim will accept, on the face of it, it wasn't a speeding simpliciter. It was cases of, one was supplementary license, driving without it. There were other cases where there was deliberate misinformation given. It's always the motive is to avoid one's identity. So that's neither here nor there. And as regards the fact that here there were 2 offences, if Ms. Lim looks at the cases I've cited, they also involve situations where there has been more than 1 offence. So in the context, I ask her for the 3rd time whether she is willing to answer, and she is capable of answering as a lawyer. All those facts she has identified are present in some of those cases.
Speaker, as I said earlier, I've consulted lawyers who are in practice and familiar with this area of the law, and in their opinion, they feel that a custodial sentence would have been warranted in such a situation based on the facts.
Can Ms. Lim identify a single case where on such facts custodial sentence was imposed? 1 case.
Mr. Lau. So on point of orders, whether this is a session for question for oral answer or a session for debate. Ms. Lim basically asked a question in matter of public interest. What is the need for the Minister for Law to invoke such a debate? Is he trying to impose some form of intimidation?
These questions are entirely capable of being answered, including the very last question I asked. If there is a case that Ms. Lim knows where on similar facts a custodial sentence was imposed. No gratification, underlying offence is speeding simpliciter, no false appeals made, no drunk driving, nothing else. Speeding simpliciter with a false statement. Let me know if there is a case where someone was sent to jail.
Which I have with me, there is one case called Tan Jack Sa. I don't have the year with me, but I'm aware that the facts are quite similar in terms of it being a
Tan
speeding
Jack Sa, there was a deliberate false appeal made. It was not exactly foursquare with the facts here. That is why, let me make 2 points. First, if all that Ms. Lim can point is one case, compared with the 7 cases I have identified, or 6, then, as a lawyer, she will agree that if in 6 cases, and we are talking about situations where the person drove without insurance coverage, he drove without a valid driving license. So many cases where this is very serious. Willfully furnishing false information twice and driving without a proper license. 6 cases, in contrast to 1 case. As a lawyer, fair-minded lawyer, I assume Ms. Lim would accept that the treatment given to Dr. Wu falls within the broad framework of these 6 cases. Let me move on. I would assume that none of us here would say, Ms. Lim can ask the questions at the end. Let me move on. I assume none of us would say that the sentence should be heavier simply because Dr. Wu is rich or famous, or perhaps some of us may not like him. Now, I will say this to Ms. Lim, rather than referring to some unnamed lawyers who she says know better, she is a lawyer, she can look at the facts and she can give us a view based on the facts. Because I think if we leave aside politics and we want to be honest and fair, then we must look at the facts, and we have a duty to the public to say exactly, based on these facts, based on these cases, I agree this is the position. It's got nothing to do with intimidation. Let's not throw words like intimidation around. Now, let me get a couple of points out of the way in this context. First of all, some mention has been made of Section 204A of the Penal Code, which I think everyone knows was not even enforced in 2005 and 2006. Next, Section 182, when Dr. Wu committed his offences, an offence under Section 182 was punishable by a fine not exceeding $1,000 or imprisonment for a term not exceeding 6 months, or both, which is exactly the same punishment for a charge under Section 81(3) of the Road Traffic Act, and I assume at least qualified lawyers won't quarrel with that. And if it's necessary, I will go through Section 182 with the House, but Section 182 of the Penal Code, apart from providing for the same penalties at the material time, is a broad general provision. Sections 81 subsection 2 and subsection 3 of the Road Traffic Act deal directly with the offence in question, furnishing of false information. So, I said there were 2 questions that were implicit in the question that Ms. Lim had asked, that Dr. Wu could have been charged under some other provision to face a heavier sentence. There is no such other provision, and if there is, I'm sure Ms. Lim will tell me. Several people have rushed in to allege bad faith on the part of the prosecution. The prosecution is an important institution in our legal framework, and I think Ms. Lim as well as other members will agree that we have to be responsible when making comments about it. It's easy to pull down and mock, less easy to build. And in the context of these facts, I trust that members will acknowledge that it is quite untenable to allege that the prosecution had exercised its discretion in bad faith, given the facts that I have set out. I mean, specific to the 3 points that Ms. Lim makes, it was Dr. Wu's idea to provide false info. If you look at the facts I've given you for the other cases, it will be obvious that in each of those cases, it was the defendant's idea to give the false information. He got the forms, and there were 2 offenses, and motive. Those are all not broadly dissimilar with these cases. In fact, the facts are more serious. Driving without a driving license and exposing people to serious claims. Now, let's go to the third question that Ms. Lim asks. Whether my ministry has confirmation that written grounds of decision will be given by the sentencing court, despite there being no appeal pending. Again, Ms. Lim will know the answer to this question. Whether the court issues grounds of decision is within its sole and independent province. The court does not confirm its decision with me, with the Ministry of Law, and as far as I know, with anyone else.
There's some clarification I want to make.
Yes, thank you, Speaker. Speaker, Minister seems very focused on questioning my competence, and I feel that there's a need.
Not at all.
I think it's apparent to everyone in the House. So perhaps I should answer point by point, the allegations which he makes, and ask him for some clarifications as well. Now, the first point is, with regard to the PQs I filed, Part C, asking whether the ministry has confirmation that written grounds of grounds of decision will be given by the sentencing court, despite there being no appeal pending. This was in the context of statements which the minister reportedly made in the press, saying that, we should not wait, make comments on the case until the written grounds of decision have come out. So I am aware that there's no appeal pending. So my question is, why make that statement unless you know that there are written grounds of decision that are going to come out? Second point is, Part B, I think all of us know that the public is concerned about this case. I did not make any allegation there that the AG's chambers has acted mala fides in any way. I'm just asking whether that statement issued by the AG's chambers has addressed public concerns. Unless the minister says that there's no public concern on this matter, which I would be very surprised to hear. Thirdly, sir, I just want Mr. to confirm whether he's actually questioning my motive and filing the question. Is he alleging bad faith on my part to cast aspersions on the legal system?
Let me take the third question first. That's easiest. I'm certainly casting no motive on Ms. Lim. What I was saying is it would be helpful in the context of statements that Ms. Lim and others have made in the past, that we can actually, in this House, debate issues, look at issues, without having to inject politics into it. Which is why, if I may answer without being interrupted, I gave the courtesy of letting Ms. Lim finish. Mr. Lau, thank you. That is why, somewhat hopefully, I went through 6 cases, fact by fact, item by item, and any lawyer will know, looking at those 6 cases, that the final result in Dr. Wu's case is consistent and falls within those 6 cases. And I was hoping for what is really an obvious answer, that having looked at these cases, Ms. Lim would be fair enough to say, yes, I agree, the judgment in Dr. Wu's case comes within the framework here. I gave her 3 opportunities. She did not. It is not a question of questioning the motive, but is rather hoping, because of these statements that have been made in various places about the Attorney General and our judicial system, that between 2 lawyers, Ms. Lim and myself, we can put to rest these allegations in a fair, transparent, open way. But it is not to be. Now, let me deal with the other 2 questions. Whether there would be written grounds of decision, Ms. Lim would know the context in which I made the statement. The period for notice of appeal had not expired. I don't know whether there would be a notice that's filed. I wouldn't know whether written grounds of decision would be given or would not be given, and in that context, I made that statement. Second, I'm glad to note that no allegations are being made against the Attorney General's chambers, and that it is not being suggested in any way that the Attorney General's chambers made a wrong choice or a false choice in choosing the charges that they did against Dr. Wu. But the context of the questions certainly implicitly raised that possibility, and because it's a serious possibility, I had to deal with it openly. That is why this House is for. But I welcome Ms. Lim's suggestion, and I take it wholeheartedly, and I'm happy to hear that no allegation whatsoever is being made against the Attorney General's chambers, so we can all at least move on the basis that they exercise their discretion properly. Thank you.